Hi, and welcome to Is That Even Constitutional? This is a show where we use the lens of the Constitution to dissect current events. My name's Sadhana Devaraja, and I am not a constitutional scholar, but lucky for me, my good friend Ken Thomas is. Hi, Ken. How are you?
Hey, Sadhana, how are you?
I am doing well. So, as folks know, this is our second season, which we're calling the Project 2026 series. This is the fourth proposal of an arc of 10, where we set forth winnable proposals that would help us reclaim the Constitution through legislation. And so far, we've covered filibuster, gerrymandering, right to access to vote with a proposal to make Election Day a national holiday. So, if you've missed those, go back and take a listen. Today, we will be talking about how to make the Supreme Court more responsive. So, Supreme Court, it's established in Article 3 of the Constitution. And so what Ken is proposing here are potential term limits. So tell us about the Supreme Court. They get life tenure. Is this a problem, Ken?
Yeah, so the Supreme Court is a institution that was supposed to be the least powerful branch. It was assumed that the Congress was going to be really setting the legislative policy agenda, the executive, the president would be executing it, and then the judiciary would be just seeing basically whether the interpretations of these laws were correct or whether they were consistent with the Constitution. However, over the last, I'd say 50, 60 years, the Supreme Court has really taken over a much broader role in essentially our political system. And consequently, we're in a position now where 9 justices are deciding very significant policy and constitutional issues that are really more significant than I think the founding fathers intentionally thought they would be. And because the Supreme Court justices now have longer lifespans, shall we say, than were possible at the time that the Constitution was written, we have Supreme Court justices who are staying in office for far longer periods of time. And if you have a closely divided Supreme Court, then it turns out that 1 or 2 people can be on the court for 30 years and can be setting policy or can be setting the direction of constitutional interpretation for that long. And there is a real mismatch between our concept of representative government and the idea of 1 or 2 people having that much power. So this just seems to be something that has been thrown off balance by the passage of time, the idea that Supreme Court justices should be allowed to serve in their office for their entire lives, essentially.
That's super interesting. I had never really thought about what it was like with the founding fathers, like setting up the Supreme Court. I knew they were part of the checks and balances system that was set up, but it makes sense that especially if, the power that they wield now was not anticipated to be the power when they were set up. It makes sense that, when it was set up, the justice was unelected, that the justice doesn't have a term limit. It makes sense against kind of the theory that, they weren't supposed to have this much power. So how do other countries deal with this? Do they have term limits? How does that play out?
Well, that's the interesting thing. The United States Constitution is, it turns out, relatively unique in this situation. If you look at industrialized democracies, we do not have other examples of life tenure for the top courts in those nations. It's just not an idea that was ever developed. Those countries tend to have either year limits or age limits or some way of limiting the top justices. Sometimes they just have set terms when they're appointed. And so we really stand out as the exception to industrialized democracies and their way of approaching this. And so this might be a reflection of how old constitutional system is, and it's also a reflection of a real distrust of the power. And the idea being is that in order to keep this judicial branch a separate power from the other two branches, that lifetime tenure would in some way lock that power in. And so you can understand why the founding fathers believed in it. The only question is whether they went a little too far in giving essentially as long a period of time as somebody can stay on the bench. There are examples of justices who've stayed on bench very, very late in life, late into their 80s. And there really is now an incentive to appoint Supreme Court justices who are young so that the longevity can extend even further. And so, again, we are the unusual country in this case.
Yeah, that longevity is an interesting point because, as you said earlier, they may remain in office for 40 or 50 years, and that's like close to the life expectancy of when this kind of was coming about when the founding fathers were thinking about this as a judicial experiment. So I think that's a really great point. And then now that we're incentivized to get folks in there younger when they're of our ideology so that we could extend that time even longer and really like kind of pervert the whole reason why we were creating this as a check and balance in the first place. So, why do you think the founding fathers did go this route? Is it just because they didn't kind of anticipate these long lifespans and this kind of gaming of the system, or were there kind of other considerations in play?
Well, it really was an outgrowth of the role of judges in England. The king, of course, had ultimate authority in England. It was slowly taken away from him by acts of parliament, but there has certainly been examples of kings essentially firing justices or firing judges for making decisions that were the king was not happy with. And that is the main concern, is that the founding fathers wanted to have the justices being a separate branch and not being encroached upon by the executive or by the legislative branch. And consequently, this really was one of the more strong separation of powers situations that the founding fathers were very concerned about, was just keeping the ultimate judicial evaluator separate from the other two branches. And consequently, the lifetime tenure, of course, made a certain amount of sense, as did the idea that even the appointing of the justices was going to be shared between the executive branch appointing and the legislature approving. And so these are just all part and parcel of separation of powers. And it was just the founding fathers made these decisions essentially with actually very little other, few other examples of constitutions, which there really were not any significant other constitutions for them to look at. So this was all very theoretical and was intended to address problems that they had seen historically in England.
Yeah, so it was intended to kind of give independence, and now it's been contorted into something else. And I think something you've mentioned before also was like the average term, even in the 60s, was much shorter than it is now, right? And so this
That's
is
exactly right.
pretty recent. Yeah, could you tell us more?
The averages were really for probably in the 60s was probably about 15 years for a Supreme Court justice, which is still a fairly long term for a Democratic body or a Democratic official. But essentially, I think we could see by the impressive longevity of the Supreme Court justices that these started running out to 20, 25, sometimes 30 years. Justice William O. Douglas, for instance, was appointed by FDR and did not leave the bench until Gerald Ford was president. So that's 7 presidents that Justice Douglas served under. And in the sweep of politics, that's just a huge period of time for one person to have significant political authority within our system. So it's really when you start seeing people stretching out that long, you really realize that this is a system that was designed in a different time, and certainly the idea that 7 presidents would come and go, and possibly wars and political upheaval, etc. And through all that, there would be individuals who essentially had no democratic check on them. And they had no limit on them, and consequently, they really were given a level of power that probably the founding fathers would have been relatively surprised by.
Yeah. And so if we are to address term limits, we said that Supreme Court is established through the Constitution. Are term limits also in the Constitution? Does the Constitution need to be amended to address this, or how would we go
So
about
that
it?
is the interesting question that I think is something that people really don't generally know a lot about. So there have been legislative proposals. Congressman Johnson, for instance, Hank Johnson, has proposed 18-year term limits, and that a new justices would be appointed every 2 years to account for the fact that justices would be coming off the bench. So these would be staggered term limits in the sense that once they were appointed, then it would be 18 years out till they're left. So that would be a legislative fix. And so what would be the judicial tenure, the life tenure that would be ascribed to the justices, would be that they would be allowed to remain as federal judges, and they would be allowed to work on other duties, such as, for instance, sitting on Court of Appeals panels or working in other judicial capacities. So, in other words, the life tenure would be kept. The judges would not be fired. They would continue to be working in the judiciary. They would just not be voting with the other justices in the Supreme Court, in the Supreme Court context, after their 18 years had come up.
Okay, so it sounds like they would be able to remain judges for life, but not serve on the Supreme Court under this proposal because there are other. Is this because there are other Article 3 courts? Is that kind
That's
of
right.
the way that it works out? Okay.
Right. So what we really have to look at here is the idea of whether or not um, life tenure would be interpreted by the Supreme Court to require that they stay on the Supreme Court. And so the arguments for this proposal are that Supreme Court justices have always, or for in many historical instances, had other duties that included sitting on circuits. So if you go back historically to the beginning of the judiciary in this country, once it had been set up, Congress had set it up, gave Supreme Court justices the job of something called riding circuit. Riding circuit meant that besides sitting as the Supreme Court, individual justices would literally get on horses, get in carriages, and then go to different locations in the country and go to different circuits and then sit on those circuits as a circuit court judge. And so this has been going on since essentially the beginning of the judiciary as it's been set up right now. And in the case of Stewart versus Laird, the Supreme Court considered this many years ago as to whether this is constitutional or not. And the court essentially found that this had the historical underpinnings that were necessary to uphold a practice by the Supreme Court. And this is something that the Supreme Court does still today. It talks about the history of a practice and the context of deciding whether it's constitutional. And not only is there a deep historical practice of the justices riding circuit that did end in the beginning of the 19th century, but there's also a practice that goes on today, which is that justices such as Sandra Day O'Connor and Justice Breyer have taken advantage of a statute which, once they have decided to leave the Supreme Court bench, they remain as justices or they remain as federal court judges, and they actually sit on circuit cases. And so there have been something like 1,600 cases decided at circuit court level that have had at least one Supreme Court justice, generally retired Supreme Court justice, sitting on that. So we not only have historical practice, but we have existing practice where Supreme Court justices are acting in capacity other than sitting on the Supreme Court. And that would be the basis for this legislation to be argued as constitutional.
And that's super fascinating. And so, I think we kind of went over this a little bit, but wondering if you could just like kind of summarize what you're seeing as the benefits of establishing these limits then.
So, what we really need to see here is that our democratic experiment, our constitutional experiment, was filled with very, very interesting, sometimes novel, and fairly subtle attempts to keep power both in check within the Constitution, but also not to inhibit it, not to make it too arduous, or not to give too much power to any one faction. And so this is essentially a mid-course correction and a way to essentially rehabilitate the Supreme Court. The Supreme Court has now become a much more political institution. I think everybody understands and agrees that the nomination process has become very political, and justices are not being chosen because of a general knowledge or ability. They're being chosen because of perception that they will vote in a certain direction regarding significant constitutional and statutory issues. And consequently, the Supreme Court has been dragged into politics. And this is something that, again, putting life tenure justices into situations which seem more political means that the institution becomes under a lot more political scrutiny. And this has been the case. So right now, the Supreme Court is very, very unpopular. It's actually at one of its lowest points of popularity in really recent times. And this is probably an outgrowth of the fact that it has been politicized and that there are not really mechanisms for this politicization to become more responsive to the American people. And in particular, if you happen to have a number of justices all appointed by the same president, as we've had recently, then what happens is that the Supreme Court is not only locked into particular political positions, but can be locked into those positions for many, many years. And this is just one more example of a number of examples we've been talking about where institutions of government are now becoming very, very unpopular and people are losing faith in them. And so this is essentially a mid-course correction to try to put some responsiveness back into the Supreme Court.
That's right, Ken. Yeah, I think, we've been trying to set forth winnable proposals, and you really like kind of hit that on the head. This is a institution that was created with the kind of desire for independence from the other powers, have that separation of powers. And what we're seeing is that it's being used as a tool to really consolidate power. And that for that reason, it's deeply unpopular. People see this happening. They don't like it. And there is a legislative fix to this that would remain constitutional, that folks have proposed, that we see would work in practice and in ways historically and recently. And so we should just get it done. Thanks for walking us through that, Ken. For folks listening, hope you enjoyed the episode. Hope you like and subscribe wherever you are reading or listening to episodes. You can always email us at production@constitutionpod.com if you want to send us any comments directly. Thank you for your feedback. Thanks for listening, and we'll see you next time.